a looming arched entrance built from thick stone, symbols of a system and its process and its history, a weighty reminder of the authority carried in and by a court of law. It's an intimidating and scary experience having to appear before a judge. It's an experience Caroline knows well. She's appeared in Supreme Court 10 times trying to resolve custody and property issues after her marriage dissolved.
I felt really uncertain and scared and timid and not like you don't know what to expect and you don't know, if you're going to say the right things or look stupid.
What made Caroline even more uncertain was that she was representing herself.
The hardest part, I guess, has been the hours and hours of preparation that goes into each appearance.
So, what do you got for me?
Caroline is what you call a self-represented litigant, or SRL. She is one of a growing number of people who don't qualify for legal aid but can't afford a lawyer. Most of the funding for legal aid is allocated to criminal cases where legal representation is protected under the Charter of Rights. Those rights don't extend into family law. Caroline spent $15,000 on legal services before running out of money. Her case was not resolved.
You strategized, come up with some tactics.
Denice Barrie is president of Waymark Law, a Nanaimo-based firm focusing on coaching and support for self-represented litigants. Caroline is a client.
Well, unbundling legal services has been around for a while, but this is more than unbundling. This is not just taking a piece of the proceeding and doing it for people. This is actually teaching them more how to cope with it themselves in a practical, personal way. I started out by thinking, these people need a lawyer, like, damn that legal aid, these people need lawyers. And yet when I got involved in actually helping them, I found that most people, even people with minimal education, can do a pretty good job for themselves.
Denice is on the frontier of making change in a system that she says is failing the people it's intended to help. She says many decisions made by the court are based in financial motivations without taking the heart into account.
Well, I believe that the justice system is undergoing a paradigm shift, moving from a time and a place where it was designed for people who would come to court with a lawyer, and so in some ways owned by lawyers and judges. And I think it's, with the number of people who can no longer afford to hire a lawyer, there's this huge growing group that are representing themselves, and they're here to stay, basically.
Caroline says she has found strength that she never thought she had, and she's impacted more than just her own life. Caroline helped to set a precedent when a judge awarded her costs, usually reserved for people who have paid a lawyer.
The court isn't an emotional thing, it's factual and it's logical, and when you're a self-represented client, you are emotionally invested in what you're talking about, so you almost do need someone to help coach you through that, to get you out of the emotional side of it and back into the logical side of what needs to be presented in court.
And that's where the coaching comes in. Denice has developed workshops to teach and guide SRLs, and she has written a book, Journey to Justice, a guide to making a good case in court.
The model that I've developed is all about giving people the knowledge and the power to be able to confront a system which, in my view, belongs to them.
Statistics show that in 2013, 57% of hearings held under the British Columbia Family Relations Act included one or both SRLs, and up to 1/2 of all family law trials in 2012 involved at least one self-represented litigant. In Nanaimo, I'm Kate Bergen.